my everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my battle.
Hello, lovely people, wonderful members of the community. It's another Saturday afternoon. Now, if you look at the weather in the UK, it's a bit wishy-washy. The sun is out at one point and it's down at the other time. The rain starts, you drive 10 meters and it stops. Then you drive another 10 meters, you fall into the rain. It's a bit uncertain. But what we have as certain is that we're bringing you the community and the law. Paragraph 39E of the immigration rules states that you can challenge the Home Office for refusing your indefinite leave to remain application. How are you going to do that? I know you are ready for the answers, and that is more reason why I invite you to join us for this edition of the community and the law. My name is Ureku Usifrimpon, I should say. I invite you, come join me, and let's get into it together.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345. Or you can send a text 07950-422-780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Oh, yeah. Grab a drink. Let's get into it together. My name is Owusu Frimpon. Good afternoon to you, and welcome to another edition of The Community and the Law, brought to you on BWTV and by BWF Solicitors, our trusted partners when it comes to the law. There's so many things that you need to know. There's so many updates have been given from the Home Office when it comes to our immigration issues and matters of the law that BWF Solicitors helps to bring you every week. And today we're coming up with another very wonderful topic. And it's by popular request. We have looked at this before, but we will want to touch on it again. How to challenge the Home Office for refusing your indefinite leave to remain application. Lawyer Charles Asma is a resource person, and he is one of the solicitors of BWF Solicitors who's going to help us do that. But before then, there are several updates. And the very first one is this. The Home Office must consider any permission to work application if an asylum claim has been outstanding for at least 12 months from the date the claim was lodged. Home Office Guidance, Permission to Work and Volunteering for Asylum Seekers, published on 28th October 2022 says that, and I want to say it again, that the Home Office must consider any permission to work application if an asylum claim has been outstanding for at least 12 months from the date the claim was lodged. So that's the very first one, and we've been doing this for several weeks, and that's week 24. Now, look at this. Court says Home Office must now provide documentation of right to work for all those who made in-time applications. In a landmark decision, the High Court has ruled that the Home Office's failure to provide people who made an in-time application and are covered by Section 3C leave with a means to prove their immigration status is unlawful. The court went on to say that it is not the applicant's fault that the Home Office takes a long time to decide applications, and therefore they should not be disadvantaged by the Home Office delay. In reality, over 100,000 applicants are affected every year, leading to some losing their jobs. That's estimated at about 40,000 a year because the employers were not provided with a digital confirmation of their right to work, although their leave is deemed not to have expired while the Home Office was yet to make a decision. The challenge was brought by a Ghanaian referred to as Miss Cecilia Ejay. It is expected that if the Home Office does not appeal, the law will be changed soon, so they will provide a digital confirmation of the right to work. Just bear in mind that if you submitted your valid application on time and Section 3C covers you, your employer cannot suspend you from work. I want to say that again, that if you submitted your valid application on time and Section 3C covers you, your employer cannot suspend you from work. This is Reverend R in the matter of Cecilia Ejay versus the Secretary of State for Home Department. It's a 2024 case, England and Wales High Court case number 1374. 1374. That's the second update I'm giving you at the moment. We move on to other ones, and that will be that last week we needed to celebrate the birthday of one of our very own. So I would want you to come join me as we celebrate our very own Chelsea Asabre. Lady Chelsea Asabre, we wishing you a fantastic day filled with joy, success, and all the good things life has to offer. Cheers to another amazing year ahead. Chelsea is in our office in Accra, and it was her birthday. I think I skipped her last week for I don't think I had a reason. I might have skipped it and I might have missed it. So Chelsea, belated happy birthday to you. Thank you so very much for doing what you do. Your smile is so infectious, and we want to say we wish you a fantastic the day is gone, but we're still in June. So we wish you a joyous month and all the good things life has to offer. Cheers to another amazing year ahead. Well, thank you so very much for sticking around. We will be coming very soon with another update. Let me put this one across as well. Notice of curtailment emailed 8 months earlier upheld as lawful. Escobar versus Secretary of State for the Home Department 2024, England and Wales High Court case number 1097, decided on the 10th of May 2024. And what does it say? The High Court has decided in a case that your leave to remain, including leave under family life, can be cancelled by email, whether or not it went into your spam email. The court found that the claimant had not been unfairly refused re-entry into the UK, where a notice of curtailment of his leave to remain had been emailed to him 8 months earlier. He had not rebutted the presumption that the notice had been lawfully given. The advice is to always ensure that the Home Office has your working email. Otherwise, you could be stuck outside the UK. I want to say that. Always ensure that the Home Office has your working email. Otherwise, you could be stuck outside of the UK. Well, Yes, we're doing our updates. It's a community and the law brought to you by BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors are on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. N15 4NP. If you're going by public transport, get on the Victoria Line train. Seven Sisters is your stop. Use exit number 2. It will bring you to the frontage of the Anna House. Climb up to the fourth floor, and that's where BWF Solicitors is. Now, when it comes to immigration matters, when it comes to appeals and various applications, divorce and marriages, family issues here and there, and conveyancing, advice on legal and properties, BWF Solicitors is your trusted source. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. 0208 493 7340. You can find the numbers at the bottom of the screen. 0208 493 7340. The Ghana number is 0055 589 5959. 055 589 5959. Or the emergency number 004477 12761884. 0044 77 12761884. BWF Solicitors. Now let's pay a tribute to them. I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Welcome back, and we're still live on BWTV. The Community and the Law is the program and is brought to you by BWF Solicitors. We are going to look at the topic where we would be going through steps and procedures where we can challenge the Home Office for refusing indefinite leave to remain application. The questions that we will be asking and, of course, getting answers from Lawyer Charles or Asma is that can children born in the UK who may qualify in their for their indefinite leave to remain application be classified? We'll look at that. The other question I will also be asking is this: can you ask for 30 or 60 months leave for your child on the same application fee, but with 5 years IHS fee? We'll also look at the reasonable test and a case of the SSAD versus AB Jamaica. How do children qualify for British citizenship? Then we will also be looking at other routes of settlement. But then, basically and most critically, we will be looking at how to challenge when such applications that we have outlined and all the qualifications you have had, and then they say they have refused it. How are you going to challenge that? The paragraph 39E of the immigration rules, what does it say? We will be looking at all those bits again. But in the meantime, let me just remind you of a nugget that I brought you earlier on. I think it has something for us to look at. The Home Office must consider any permission to work application if an asylum claim has been outstanding for at least 12 months from the date the claim was launched. Then we have also situations where people say or give the excuse in challenging refusals that the email, yes, you said you sent me an email, but I didn't find it. It went into my spam and all that. What is it that the Home Office is saying again now? The one about the spams, the Home Office may refuse that. It says the High Court has decided in a case that your leave to remain, including leave under family life, can be cancelled by email, whether or not it went into your spam email. People give the excuse, as I was explaining earlier on, that, well, I didn't receive the email. It went into my spam. When I found it, it was way past the time. What do I do? The court found that the claimant had not been unfairly refused re-entry into the UK, where a notice of curtailment of his leave to remain had been emailed to him 8 months earlier. He had not rebutted presumption that the notice had been lawfully given. The advice is to always ensure that the Home Office has your working email. Otherwise, you could be stuck outside of the UK. So I would want to really advise you that if you are giving any email address to the Home Office, it must be something that's workable and you have access to all the time. Don't get yourself into that tricky situation where you would want to give the excuse that, well, I didn't receive it. The High Court has decided that your leave to remain, including leave under family life, could be curtailed by email, whether or not it went into your spam email or not. Okay, now later on, I still would want to get this to you. Later on, I'm going to get you to answer my quiz question, and this is a scenario I have put together. Deliberately, I went over the nuggets so you could have a few. Now, check this. On 20th April 2023, Kofi Asare arrived in the UK with a visitor's visa. He arrived at Heathrow Airport, and when the immigration officer searched his luggage, they found another birth certificate with a different parent name for his father. Therefore, they detained him since they became suspicious that he did not have a relation with the father. Mr. Asare then made his asylum claim, and after a year, the decision was still pending. Okay. Can Mr. Sari obtain a working permit as an asylum seeker? Is it one? Yes, if he is a dependent on his father and over 18 years old. No, because he is an asylum seeker and was detained. 3, yes, because he put in his asylum claim at least 12 months ago. Or you can decide to say, well, it's none of the above. There's one update that relates to this. Let me quickly go on to that, where it says that Home Office must now provide documentation of right to work for all those who made in-time applications. In a landmark decision, the High Court has ruled that the Home Office failure to provide people who made an in-time application and are covered by Section 3C leave with a means to prove their immigration status is unlawful. In reality, okay. Now let's look at this as well. The court went on to say that this is not the applicant's fault, that the Home Office takes a long time to decide applications, and therefore they should not be disadvantaged by the Home Office's delay. In reality, over 100,000 applicants are affected every year, leading to some losing their jobs. It is estimated about 40,000 people a year lose their jobs because their employers were not provided with digital confirmation of their right to work, although their leave is deemed not to have expired, while the Home Office was yet to make a decision. The challenge was brought by a Ghanaian referred to as Ms. Cecilia J. It is expected that if the Home Office does not appeal, the law will be changed soon, so they will provide a digital confirmation of the right to work. So just bear in mind that if you submitted your valid application on time and Section 3C covers you, your employer cannot suspend you from work. In a while, we will be bringing you Lawyer Charles Osma as we get into our discussion for this afternoon. But before then, this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Yes, and thank you for joining us, and thank you for sticking around. We're looking at the topic, as I mentioned, how to challenge the Home Office for refusing your indefinite leave to remain application. And we have our resource person and our guest from BWF Solicitors, lawyer Charles Asma, who is going to take us through that. And lawyer Asma is seated, lawyer Asma is ready, and I will go straight into the question. Boss, indefinite leave to remain, when it is refused, is there any hope of getting it reversed? Maybe when you'd have set your greetings and everything, not to catch you on the spot. When it is refused, is there any hope of getting it revised or reversed?
I think the key word is hope, and there is hope.
Okay.
And the topic for today has context, and the context is paragraph 39E of the immigration rules, which talks about the fact that it shields you from any a problem that may befall you for whatever reason and for what the Home Office may say. So it's a shield. And we talked about the fact that because it's a shield, it's not like Section 3C, which is a sword. So we're looking at where paragraph 39E, even though, so where paragraph 39E appears to be a shield, and the person has actually used it in a way that does not undermine the protection under 3C. And the Secretary of State thinks that the Section 3C provision, paragraph 39E provision was used to be able to progress the application process. For whatever reason, they missed something or whatever, and the Home Office thinks that no, we can't see something, and therefore your application is refused because you do not meet the rules. Where does the person stand to challenge this, knowing that the person has not engaged paragraph 39E, only stayed within Section 3C, but the Home Office is saying, no, you operated under 39E. The person says, no, I operated under 3C. How do you challenge that?
Okay. Now, you've said three technical things. Paragraph 39E and Section 3C. What do these two say? And why would anybody go and say, I'm depending on 39E, and somebody will say, well, I'm protected under 3C. What do those two things say?
Sure. So paragraph 39E is a provision within the immigration rules, which is a grace period for those who are late to submit their application. Late. What do I mean? If you are doing it for the first time, there's no lateness because you don't have it already anyway. For it to expire. So then for those who are renewing. So the key word is renewing. So if you are renewing your application or your visa to remain in the UK, you have to check whether you are operating within the grace period under paragraph 39E, which says that if for whatever reason you miss your deadline, which is the last day of your visa, the expiry date of your visa is the last day of your visa, 11 p.m., 11:59 p.m. of that day. If you missed and you submitted the next day, which is 12 midnight, which is the next day technically, or any other day, within 14 days, you have missed the deadline. Therefore, the immigration grace will be halved. Halved in a sense that instead of getting the full grace, which only 3C gives, you are getting half of the grace, which is the fact that you are operating within the 14 days. I'm using this to make it easy because these are technical,
they're quite technical
phrases. So what do we mean by paragraph 39E? It simply means that if you are renewing your application and you don't renew on time, you miss one day, but you're able to do it within the 14 days, you are okay. The application will be decided.
That's what 39E says.
Yeah, paragraph 39E. The application will still be decided because you still came, even though you are late. You're
still within the grace period of 14.
You have given all your reasons. So that's fine. Still 14 days grace period. So we give you half grace and accept and process the application. However, because the grace is halved, when you are ready to renew, when you are ready for your indefinite, we'll come back to tell you that the grace that you lost, you have to make it up at the time of indefinite. We'll come to now. Let's look at 3C.
3C, good.
3C says that whilst your visa is still valid, what we call exempt leave, whilst your visa is still valid, and you apply latest by the last day of your visa, 11:59 p.m. of that day, you submit, and the time and day shows that you submitted before it expired, then you pushed the trouble to the Home Office. So it expired in their hands.
In their hands, okay.
If that's the case, your full grace is maintained.
That's the 14 days.
No, your full grace, which is under the immigration rules that you have lived.
No matter how long it takes for them.
No matter how long it takes
for them to make that decision,
will follow you
okay.
to indefinite day.
Oh, okay.
And what it means is that when it comes to your employment, your right to work and whatever, you'll still be okay.
Okay.
Again, when it comes to your right to work, whatever, under paragraph 39E, the half grace, you're still okay. Your right will remain. However, the automatic right, which is the indefinite, when you get there, they will then sit back and tell you, remember, we just pardon you so that you can go through. But it doesn't mean that you merited the progress.
Okay.
And at this point, where you are ready for indefinite, we are reminding you that your date is not up yet. So make it up.
So how do you make it up?
Good. But because the conversation is different, I'll touch up on how to make it up.
Then we'll look at
the main, where somebody has been refused and the Home Office thinks that the person operated under 39E. However, there was no 39E engagement on the person's part. You can see it's a mistake on their part. And you're challenging them that, hang on, look at the records. Where have I faulted? Then they sit back and say, sorry, please.
Because you applied in time.
Now, the bit about how do you make it up. So this person, for example, I have 2 waivers that I'm working on now. The first waiver has been approved on the 10th of June. So once waiver is approved 10th of June, you are given for 10 working days within which to apply. In other words, submit your main application. Yeah. Let's assume that for whatever reason, this person, please wait for me, please wait for me, please wait for me. The lawyer is, give me what I need to be able to submit. Oh, please wait for whatever. Then 11th working day, we submit. What then happens is that the voucher for the fee waiver will not work. So you have to pay to submit. If the person is paying to submit, they are submitting out of time because the visa had already expired at the time they were waiting for their fee waiver. But you are given 10 working days to submit because if before your waiver was put in, you had leave. So your grace continues with you or remains with you. So if we are submitting on the 11th day because of the person's fault or whatever, then once it goes to the Home Office, they may consider that's fine. Let's say that because the 10 working day is part of the section 3C, the 11th day will then fall under 39E. Because then it falls in the grace period of 14 days, technically. So they will take it, you pay, and you submit. Because you can't do fee waiver again because of time. You submit, you go. But when the person has gone through the two and a half processes, they will come back and say, hang on, look at this. Because you submitted 1 day late, and it stayed with us for 1 year, making 1 year. Let's say it stayed with them for 364 days, plus your 1 day, making 365 for simplicity. So that is 1 year, 12 months. You think that you have had two and a half, and therefore you are ready today to submit. Then they tell you that, hang on, you have debt or arrears in days of 365 because yours was 1 and it stayed with us before the decision came for almost.
But obviously it wasn't the person's fault.
All right.
The 1 day, yes.
Yeah.
So if I'm to make up for anything, it has to be the 1 day because the decision, or you took 364 days to make that decision.
That was the point before. But there's court ruling which came recently to say that before 39E will shield you and cover you forever, full grace.
Okay.
The court now says that no, 39E cannot be full grace. It's half, and therefore it's only going to shield you so that you can progress the application rather than becoming illegal. However, once you get to indefinite, cannot benefit from the delay at the home office plus your own delay. The question, who caused the delay at the home office?
At the home office, yeah.
Technically, no, but technically you caused it.
Because of the one day?
Because you made it happen. You started.
Last man,
it's
a technical thing. Yeah. I get your point. But then people could make applications, or they do make applications in time. And it spends over 6 months with the home office. Would they say that it's their fault? Would they admit it's their fault? And would that go against the person when you are applying for your indefinite, for instance?
So the phrase you've used is in time. Mm-hmm. If you make the application in time, you have your full grace under 3C.
Okay.
You are protected.
Okay.
But before your visa expired, you have submitted.
Whether, so then that wouldn't affect
whether 1 minute early, 1 second early. Let's say the person submitted 11:59 dot, but at the end they say submitted. Then the next minute 12 midnight. The next day. Mm-hmm. When did they submit before it expired in their hand? Yes. So that's 3C. It doesn't matter how long it stays with it delays at the home office. You are covered.
Okay.
But we are looking at where you began the delay.
So even if it is 12 midnight,
yes,
which is the beginning of the day after the expiry,
yes,
then even if it is 1 second,
you have entered the 14 days.
You have entered the 14 days. So then you have to make up for it.
You have to make up for it.
And if it delays with them,
you still
have to make up for the delay.
So more or less double punishment, isn't it? Double jeopardy for that mistake. So what does this tell us? Mm-hmm. It tells us that we have to be sure not to apply after expiry date. Don't use the 14 days. Yeah. Based on this,
well, it shields you, but not a sword.
It shields you, but it can't use as a sword when you get to indefinite period where you have to pierce to get the indefinite.
But we were on the question where how to make it up before we come to how to appeal against it. How do we make for that
delay?
So the delay. So it means that if we had 365 days, like in your example, then it means that your indefinite is short by 1 year.
Very good. That is exactly what the court says. So technically, your indefinite is short by 1 year, so you are not due yet.
And you can't apply 1 year before your time is up.
Well, what it means is that, let's say you think that you are due. Mm-hmm. You have maybe 6 months to go, but you are in deficit of 12 months. So you are making so technically you are in deficit of 6 months.
6 months.
Once this 6 months has elapsed. Mm-hmm. So once this visa, the last 6 months has expired or is about to expire, you have to make an application to extend for 2.5 years. However, that 2.5 years, once it comes, it will be the case that because you are in deficit of technically 6 months.
6 months.
So you don't wait for the full 2.5 to expire.
So when you have covered your arrears, then you can put in your indefinite.
So you have to then calculate your arrears and ask yourself, how long will it take me to recover?
Okay, so if I get you right, if you know that you have an arrears of 6 months, which you would have to cover, when you are putting in your application, you would want to add 6 months to when it would expire to do that, or you may also stand the risk of being illegal. So you calculate the 2.5 as it would have happened, then expect that you spend another 6 months. So then you renew for 2.5, then spend 6 months within the 2.5 and put in your application for indefinite. That would have covered you. So your punishment will be time and extra money.
Time and, of course, good. Time, extra money, and emotional trauma you go through. So what does this policy tell us? It tells us that we can no longer operate within the 14 days grace period unless you have no choice. But if you have a choice, avoid it because it is no longer a sword.
Okay. Well, folks, it doesn't really sound pleasant, but the law and the High Court, technically, as Lawyer Charles Asma said, is saying that if you can avoid, don't operate within that grace period. And thinking that 39E will be protecting you. If you would want to have any grace period, operate within 3C. That is, apply in time. So if it goes and it delays with the Home Office, you will be protected for as long as the delay ends. But if you cause the delay, whatever time it spends there, you would have to pay back. That's what it is. Now, our question again is, how do we appeal against the paragraph 39E of the immigration rules when they have refused your indefinite leave to remain application? Layasman.
Thank you very much. So the point here is for someone who has not engaged paragraph 39E. However, the Home Office thinks or believes that they engaged it, and therefore they have to make up for the deficit in time. And because you have to make up for the deficit in time, they will not grant you indefinite. They will grant you another 2.5.
Okay.
So that, because they won't refuse the application, because you have to have something.
Okay.
All right. So once you have it, thinking that I made the application for indefinite, why have you given me this? If you still have leave, they will reject the application to be invalid, so that you wait and make a proper application.
Okay.
Or wait till the leave actually expire before, or about to expire.
So then they will write back to you to say you don't qualify for indefinite. So wait till your time is up.
So make the right application technically, which will be further leave to remain. Now, if the leave is expired already, because you applied the last day, then there's no point for them telling you that it's not valid to make another application. They'll give me what I will make. So they'll give you 2.5.
Okay.
Now, so this is somebody who has been granted 2.5, because the Home Office thinks that the indefinite leave application was not due because paragraph 39E had been engaged at the point of that renewal or final application. So we have to check the record.
Okay.
There are things the Home Office may be picking up on, and we are going to address. One of the reasons why the Home Office may say that they think paragraph 39E was engaged will be that somebody might have applied for a fee waiver.
Okay.
Fee waiver is successful, and they are given 10 working days to make the application, to submit the main application using the fee waiver voucher. If for whatever reason, as I was explaining earlier on, they don't operate within that 10 working days, they will lose the fee waiver voucher. But let's assume that this person realized that, oh, I've lost the fee waiver voucher. I cannot make another fee waiver application to take me another 6 months. Let me just pay and submit. So that I will operate within the 14 days. Or the person says that I'm still within the 14 days. So I'm making another fee waiver application to start.
That's going to take you a long time.
So, on and on. So that's what the Home Office will think. So it is up to you to challenge them to say that, hang on, you gave me fee waiver approval on this date, and you gave me 10 working days. 1, 2, 3, 4, 5. 10 working day, I calculated and I submitted on maybe the 9th working day, or exactly the 10th working day. But the fact that it went through means that the waiver was still valid, the code was still valid.
Okay.
What do you have to prove that you submitted in time within that 10 working day? What do you have to show them? Confirmation of application.
Confirmation of application, yes. When you would have clicked and it says submitted.
Submitted. Either that one or the application itself, application form itself. Because when you submit, you have the copy of the application to print. You have it there, date and time. Date and time on it is for a reason. Otherwise, why didn't they just put the date? They did put the time too. Because time is of essence.
It's of essence, yeah.
And therefore, you're able to calculate and tell them, hang on, I submitted on the last working day, 11:59 p.m. It's on it.
Yeah.
So why do you miss it or misinterpret it to mean that I submitted
late?
But I submitted on, let's say, 1:59 a.m. While it was 11:59 p.m. That's not late. That's in.
Yeah.
So hang on, you've gotten it wrong. I never engaged 39E. I operated under 3C, and therefore I still have my sword to be able to pierce through the grace of indefinite.
So as I keep saying, evidence is the name of the game.
Of course.
So when you submit your application, check the date, check the time.
Very important.
And that would come as a sword for you to pierce through
the indefinite grace.
And then operate under 3C, not 39E.
Fantastic. So that is for somebody who was granted indefinite leave to remain, and for whatever reason they missed the time to submit, and they submitted late within the 14 days. But you're able to challenge them that no, that's not the point. Or somebody who was not granted the fee waiver. Because for instance, where you not be granted a fee waiver, if you are not able to prove that you are either destitute or you cannot afford the fee, or even if you can afford, after affording the fee, you will be imminently destitute because you cannot then afford the essential living needs yourself and the children involved. It is a human rights application. So this person couldn't prove that they deserve fee waiver, so they were refused and told, oh, now submit in 10 working days and pay and submit within 10 working days, because you can't have it for free. And they will tell you that the starting date, the exact leave, will be the date you submitted the fee waiver. So we go back and check, when was the fee waiver submitted? The fee waiver was submitted before the visa expired. That means the person had exact leave and operated under 3C. Fee waiver has been refused, and the person is told that even though you are refused, if you can afford, if you can now pay and submit, we'll still take it that you are under 3C protection. Now this person, for whatever reason, says, I'm looking for money, I'm looking for this. They do not submit, then that will go under 39E. But this person submitted. They got the money and submitted 10:59 p.m. of the 10th working day of the fee waiver, from the date of the fee waiver decision. They have the time they submitted, they have the fee waiver date, and the fact that there was 10 working days to operate within. They have all these pieces of evidence. So they will tell the Home Office that, hang on, look, you gave me fee waiver decision, which you denied me. You gave me 10 working days to apply, which ended on this date up to 11:59 p.m. And I did it on at 10:59 p.m. So why do you then say that you think it was the next day?
I'm not throwing anybody under the bus now, but do they deliberately refuse these applications?
Which one? The fee waiver?
Not the fee waiver, the main one.
Reject?
Reject, because they say that they have reason to believe that you do not apply in time. But meanwhile, on the application form that they would have received, the date and time would be there.
What does it tell us? It tells us that only God is infallible. Every one of us is fallible, including the Home Office. So when they get it wrong, we don't have to be surprised.
But this should be an excuse, because if I did something that was a mistake on my application form, they will come back to tell me, I'm refusing you because you did X, Y, Z wrongly. So why don't they get it right?
Very good. So, I mean, as I said, the starting point is that they are susceptible to error. So they make mistakes. Once they make a mistake, you only challenge them to point them to the right direction. That, hang on, this is a mistake. It might not be deliberate, but it's a mistake, and therefore fix it. They will fix it for you based on the evidence you've provided. And if you think, as a result of that mistake, it has cost you whatever loss, you can take them on and recover your losses.
Do people often do that?
Well, the question is whether people do that. People have the right to do it, but it's not always the case that we will assert our right.
Yeah, because why I ask that question is that you Home Office, you've put me in a precarious situation. Obviously, there are consequences. I've lost money, I've lost time, my emotions and all these things are affected. Then when I'm putting in the appeal, it's going to cost me a lot of money, because The lawyer who is filing the appeal for me will charge me. An appeal fee is there. I may even have to pay for another set of fees. So I think people should challenge them
of course,
and take their monies back.
Yes. So, I mean, the law allows, for example, if somebody has gone through that situation and the Home Office says that we've given you 2.5 instead of indefinite because you operated under 39A, so you were not due at the time. And the person has evidence to show that they never engaged 39A, they will have to present the evidence and put them on notice that, one, they reverse, and two, you want to recover your losses. So you send a pre-action protocol. And in the pre-action protocol, you tell them to reverse the error and also offer you compensation for the loss incurred as a result, you have incurred as a result.
So if you did a pre-action protocol, just prompting them to the mistake they have made and they correct it, do you have to go through the appeal process, or once they have corrected it, it solves the matter?
The question is, what did you seek? So you have to establish the remedy you want from them. They've made a mistake, yes, and you want remedy. So if you want 2 remedies, point it out. That I want what you should have given me, and also compensation for what you've cost me.
Does it have to go through court?
So you are telling them, so the essence of pre-action protocol, what action? Action that I'm taking you to court.
Okay.
But I'm putting you on notice that if we don't deal with this among ourselves, it will, the big brother will hear about it. Big brother is the court.
It's the court, yes, obviously.
And so the essence of pre-action protocol is for us to deal with this informally, what we call alternative dispute resolution process. So instead of going through the mainstream dispute resolution, we want to go through alternative dispute resolution. You and I, let's agree and resolve it. That means when you are putting them on notice that they have to reverse it and you want compensation, you have to itemize the compensation you want. As a result of this, you have to get another legal service costing you X amount. As a result of this, your employer says that don't come to work and you have lost maybe money for this period. You put all this together, what we call economic loss. If you also feel that you have suffered psychiatric damage or what we call emotional damage, then that one is difficult to quantify, or you need medical assessment to show that as a result of this, this has happened to you. But suffice to say that if you have spent money and lost money from employment, then you put it together in the pre-action protocol that reverse it to indefinite and give me compensation because I've spent this amount as a result of your mistake. If they don't, then you go to Big Brother to resolve it for you. And over there too, if you spend extra money, once Big Brother has said that, but this way you shouldn't have come to us, you should have resolved it. Give them the thing and then pay their law cost for coming to us.
Okay. Well, if you just joined us, we're having a very interesting and lovely discussion there. Your rights are being spelled out to you. But listen, do it right. Stay within 3C and don't go use 39E because it could create problems for you. But if they made a mistake and they pushed you into 39E and you think that 3C should cover you, please challenge and claim all the things that you need and write to them. Pre-action protocol, as lawyer Charles Asma has mentioned, and or go to Big Brother, file an appeal in court, and the judges will grant that if they find it necessary for you to do that. In the meantime, we would want to say thank you to BWF solicitors who have been very gracious and generous to give us the opportunity to come your way every Saturday with the program, The Community and the Law. This afternoon, our resource person and guest is lawyer Charles Asma. How to challenge the Home Office for refusing your indefinite leave to remain application is what we are discussing. You can send in your comments to the comment section below on Facebook and YouTube. We're live on Facebook at BWF Solicitors and BWTV. We're live on YouTube at BWF Solicitors and BWTV. I've seen most of my compatriots and clients and visitors and viewers there. Margaret Dumensa, Lyrical Black, Tilly Duma, Abna Ativo, Kevin Asamoah, Linda Ade, Nana Ya Adubia. We have Bua Naomi. You sent in a question. I'll be getting Lawyer Charles Asma to look at that for us. But before we take a break, Lawyer Asma, when we have seen that they made a mistake and we challenge them on pushing us to 39E instead of covering us with our sword, which is a 3C, does it take a long time before they rectify that, if we correctly pointed out?
I mean, the time is relative.
Mm-hmm.
So I cannot be definite with how long.
Mm-hmm.
But suffice to say that once you point it out to them, they will review it and come to you within a short time.
Mm-hmm.
You want to know how soon or how long it will take. I should say within 3-6 months, they should come back to you.
Within 3 and 6 months, they should come back to you. I would want to insist and reiterate that. Look at your rights. Insist on that. If you have evidence that they have not dealt with you correctly, challenge them. At least get your lawyers to start with a pre-action protocol. And if you want the right lawyers to do that for you, I'm asking you to visit BWF Solicitors, 214-218 Tottenham High Road, Seven Sisters, North London. London N15 4NP. Call them on 0208 493 7340. If you are outside of the UK, they have an office in Accra, Ghana, 055 589 5959. Or the emergency number 077 61884. Now get your comments ready, get your concerns ready. We're going to get Asma to delve into that for us. It could be about a topic that we are discussing, paragraph 39E of the immigration rules, how to challenge the Home Office when they refuse your indefinite leave to remain. And remember, it's about 39E. We have looked at what 3C protection is. 39E protection, whatever it is, when it comes to your indefinite, you have to pay back. So avoid 39E and stay with 3C. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you for sticking around. So your comments and your questions are ready now for us to pick up. So go to the comment section on Facebook, BWF Solicitors, BWTV, and go to the comment section of YouTube, BWF Solicitors and BWTV. You can send us a text on 07399208468. 07399208468. Same number for our WhatsApp, 07399208468. We have Citizen Kwajo. Good afternoon. Thanks for the good work you're doing for the community. It is so much appreciated. Citizen Kwajo says Kofi and Amma are separated but co-parenting. Amma has taken the child to her home country several times and stayed there for a year, but is refusing to allow Kofi to take the child to his home country. What legal action can he take? And can he also stop her from taking the child to her country going forward? The child in question holds both Ghanaian and British passports. Secondly, can an IVA have any effect on one's application? Leasma, a double-barreled question from Citizen Kwajo. Kofi and Amma are separated. You're co-parenting. Amma's taking the child to her home country several times and stayed there for a year, but is refusing to allow the man, Kofi, to take the child to his home country as well. What legal action can Kofi take? Can he stop her from taking the child to her country going forward? The child in question holds both Ghanaian and British passports.
Thank you very much. Yes. So, Susan, when it comes to children, their care and support is for parents involved under the Children Act 1989. And once the parents do not agree, they have to go to court for court to tell them how to progress with the care of the children.
Mm-hmm.
From what you've told us, we deduce that you have agreed with the woman that you look after the children without the intervention of the court. Because he hasn't said that he has a court order. What it means is that the woman is free to send the child away, provided you do not raise an alarm or you do not contest.
Mm-hmm.
You do not prevent her.
Mm-hmm.
You've been very kind. Anytime she wants to take the children away, you don't say anything.
Mm-hmm.
But when it's your turn, she says something. She's being smart. Now, because there's no consent order from the two of you, which court has approved, or there's no child arrangement order from court,
mm-hmm.
It's more or less between the two of you. You have to speak to elders to resolve it, so that when you also want to take them away, you can be allowed to do so. But if elders are not able to resolve it, and even if elders have spoken and the lady is still adamant, then you have to go to court to assert your right. The court would then pronounce or order both of you regarding the care of the children. And once that happens, you have protection within the law or under the law to stop her from taking the children away from the jurisdiction for more than 28 days.
Okay.
In this case, if she's taking the children away for less than 28 days or up to 28 days, insofar as she has the right to have access to the children or spend time with the children or the children living with her, she also has the right to take the children abroad for holidays, 28 days. But if there's court arrangement and she wants to take them away for more than 28 days, she needs your permission.
Okay.
If she doesn't give you permission, you can sound the alarm bell. Tell the court, tell the police, you tell the particular social service, the council involved. And there's something we call the tipping off service. So you tip off and they will have to find any other way possible to bring the children back or the child back.
Oh, okay, all
right. So I think his question is, can I also have it? Can I also have it? Well, if you can also have it, then you have to speak to her to give you so that it becomes reciprocal. If that's not happening, go to court. But once again, if there's court involved, you cannot also take the children away for more than 28 days. She will also do the same or take the same action. Okay. You were asking a question.
Yeah, I was going to say, what legal action can he take? But yes, you've just addressed it, that you have to go to court and get the order. So both of you would be bound by, and one cannot go against what the order dictates. This question is asking whether the man takes that legal or the legal action and good for that. If the lady contests, what happens? Then the judge will have to make a decision on that, isn't it?
Well, the lady would. The man is not contesting that I wouldn't let you take the children away. The man is formalizing the arrangement between himself and the child's mother.
Okay.
So that informal arrangement that you can have them for some time, you bring them to me for some time, and so on and so forth.
It's now put on paper.
It's now put on paper, and
you have signed.
So what you do is called consent between the two of you, and the court will approve it and becomes a consent order.
Okay.
Once you go contrary to the consent order, it is as if you have gone contrary to the court order or judgment, because that is court approval. So in terms of action, you have to then say that, you know what, it's like we are not agreeing on what is best for the children.
So then
let's formalize it.
Formalize it.
Then once it's formalized, you have full protection under the law.
Okay. The second bit is IVF.
IVA.
IVA.
Yeah.
What is that?
Individual voluntary assessment is to do with those people who are not able to pay their debt, and they offer themselves up to be assessed that you are bankrupt. Well, not bankruptcy, but you are not able to pay the debt. So we are going to consolidate the entire debt and formalize the process. So some of the debt will be literally written off. Yeah, you know, there's that arrangement available for those people. And sometimes when you are making certain applications, not home office application per se, but certain applications, you know, sometimes when you are making some job application, they ask you whether you have CCJ, you have IVA, you have this or you have that. IVA means you are somebody who is not able to pay debt, and you have to have intervention of the third party process, literally. He's asking whether that will affect home office application, not necessarily.
Okay. Well, we have Naomi bringing us this question. Hi, good evening, Brokwiku and lawyers. I hope you're fine. We're good. I separated from my husband. I didn't do divorce, but I had went to Ghana to do it, which I have not signed for. I have now got a new person I want to get married to from Ghana. How would I prove that divorce, please?
Okay, so this is somebody who says that there is ostensibly a divorce certificate. She believes that the husband procured that divorce certificate without her consent. In the UK, the other party must approve or acknowledge. Right. And if it's not acknowledged, you have to contest it in court before the process is finalized. Elsewhere, in other jurisdictions, it's possible that the other party was not even aware that the other is seeking divorce against them. So what this person is saying, that the husband sought divorce, they are not aware because they didn't even hear to sign or anything, more or less behind their back. The person is asking whether they can bring, they can remarry, literally, thinking that there is divorce.
There is divorce, yeah.
If there is divorce, of course, you can remarry and bring the new husband. However, you must prove that this is the divorce certificate. So if the divorce has already taken place, ask for a copy of the divorce certificate. Obviously, if you have a copy of the divorce certificate and you believe that this is a divorce certificate that you want, then I don't think you go further to say that you didn't sign.
But how does she get the divorce certificate? I'm getting the feeling from the question that, well, the person has done it on her blind side.
Yeah.
The person has gone ahead to marry another person. She has also met another person she wants to marry. If she asks and the response is not forthcoming, or she doesn't get the divorce certificate, what does she do?
Right. I mean, so the other person definitely has it. Because if the other person has remarried and applied under that new wife, then the person would have provided evidence of their divorce from our questioner. I can't get it from him. What do I do?
Yeah.
Well, you go to the court where the person procured the divorce certificate to get a copy. If that is not possible, and you think that, oh, after all, there was no divorce at all, then you can initiate divorce proceedings if you believe that there was no valid divorce.
So in the UK, for instance, if somebody put in a divorce application and I'm not aware, but on my side, I feel that I should start proceedings, divorce proceedings, and I put in an application. If it props up that such a person has initiated the process against me, and I'm also initiating the process against her, would the court really reconcile the two and put both of us on notice that you have done something, the other person has done something, so consolidate both?
Well, there are different jurisdictions. You can bring legal proceedings for divorce in the UK, provided you meet the criteria. One of them is that one of the parties must be resident in the UK, and they have been resident in the UK for at least a year, and so on and so forth. Once you pass one of the tests, you qualify.
Okay.
You need to show full copy of the marriage certificate.
Okay.
But the question, this is not a legal question, a common sense question. Nobody would divorce twice. And therefore, if it is true that the person has divorced or been divorced, they wouldn't start another divorce proceedings. So the presumption is that either the divorce was not valid or there's none at all. So if this person believes that there's none at all, or even if one was started, it didn't end, or it wasn't valid, then it has to be restarted there or restarted elsewhere if the laws allow.
Okay. If you just joined us and you want to put in a question to Lawyer Charles Asma, the telephone line is active now. You can call in 0208-493-7345, 0208-493-7345, or you can go to the comment section on Facebook and YouTube and type in your question there, like the two earlier colleagues have really done that, and we've got Lawyer Asma to address those. So you can send in the question to the text message phone as well, 0739920848, or send in a WhatsApp message to the same number, 0739920848. It's the community and the law. The lines are active. Lawyer Asma is here, and we will be picking up, like we're doing this one, for Equia-Free Ajimandia. My husband is on a skilled worker visa and the sponsorship license is on appeal. Can we file and bring our children back home? My husband is on a skilled worker visa and his sponsorship license is on appeal. Can we file and bring our children from back home?
I think we answered this somehow the last, was it Friday? Yeah, however, we'll go over. So let's go to where the issue is. So the husband is the skilled worker migrant. The husband visa is questioned at this point.
Yeah. By
virtue of the fact that the employer's license is under investigation. So to speak, the husband is not 100% cleared.
Okay.
You agree?
Yeah.
So if you are not 100% cleared, on what basis will you bring somebody to join you?
Yeah.
You are shaking. They want to offer shelter to somebody.
Mm-hmm.
So the response I gave the last time was that they must wait till that investigation is over. So that the reason is it will be picked up anyway. They say, hang on, the license is even questioned, and therefore it's likely it will have impact on the so-called visa that your father has, because it's in a child application. Either they will say we wait, or they will refuse you and say that it's too soon.
Okay.
So yeah.
0208 493 7345, or go to the comment section on Facebook and put that one there. Then I want to implore you to like the page and share as well, so that people will benefit from the experience of the knowledge of BWF solicitors. Can skilled workers apply for fee waiver? Emmanuel is asking, Laura.
Right. So there is law called Human Rights Act 1998, which stemmed from the European Convention on Human Rights.
Okay.
So whenever EU then passed a regulation, it has to be transposed into law. It has to be seen to be effective. So EU passed a law called Human Rights Act 1998, saying that human rights must be protected. So there's a section called Section 3, which says that any act by the government or agent of the state that more or less engages or undermines that human right the person has, that action itself is not good.
All right.
That's the context. So the question, the application that we are discussing or looking at, is it a human right application?
Okay.
So the fee waiver came because if somebody is making a human right application and they cannot afford, and you tell them that if you can't afford, go to hell, in quote. Then what you are telling the person is that if you can't afford, you cannot accept your human rights. That's breaching Section 3 of Human Rights Act 1998. Which says that whatever you say or do which undermines human rights is bad. And fee paying, which is a condition to human rights application, is bad. So the option was that if you can't afford, you have to then ask for permission to be given concession to make the application for free. So that's the essence of fee waiver. So anybody who is making a human rights application can ask for fee waiver if they cannot afford and they meet the criteria for fee waiver request. Our questioner is making a skilled worker application. Is that a human rights application? No. Therefore, can fee waiver hold? No.
0739920848. That's the text and WhatsApp number. You can call on 0208-493-7345. Remember, we're coming your way courtesy BWF Solicitors, located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. 0208-493-7340 is their telephone number. Give them a call and book an appointment and see the lawyers. We have lawyer Charles Asma, lawyer Eunice, and the senior partner, Uncle Ben. BWF Solicitors, the emergency number is 077 127 61884. 077 127 61884. I will be going to the quiz section very soon. But before then, let's pick the nugget and read that. Then I'll drop the question, come back to take a few comments and concerns and questions. Then we will definitely go to the question. So let me have a sneak preview of that. Can we get the nuggets? Home Office must consider any permission to work application if an asylum claim has been outstanding for at least 12 months from the date the claim was lodged. The Home Office guidance, permission to work and volunteering for asylum seekers, published on 28 October 2022. Last one. I skipped this, but if I could ask you to help me just unpick this one briefly. The Home Office must consider any permission to work application if an asylum claim has been outstanding for at least 12 months from the date the claim was lodged. Can you just open it up a bit for us?
Right. So the key word is they must consider that application. What it means is that they cannot dismiss it and say that you don't have the right to work and therefore we can't even look at your application. They have to consider it.
Okay.
The law doesn't say they must give permission. So they have to consider the application for permission to work. Now, somebody will make a human rights that's a part of human rights application.
Sorry.
Which is,
let me get you to take a sip of water. Now, when we come back, we'll look at that. Can we take a break now?
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay. Yes. Last one. Yeah, you were on the point explaining that bit. Can we just pick it up again?
So we're looking at Home Office own guidance, and this is that of October 2022. So if you've made a human right protection application or simply sought asylum in the UK, the application must be decided. Oftentimes it takes longer than usual. So the Secretary of State made it clear in this guidance of 2022 that if the person has waited for 12 months, that's a year, they can apply to work, apply for permission to work. Application is one thing, success of the application is another. However, the person, if they made the application and is solid, they can be given the permission to work. So the point is, they can be given, but not necessarily must be given. Because the guidance says that the application for permission to work must be considered. It doesn't say the application must be granted. So once you make the application, it will be considered. But whether it will be granted or not depends on how you made the application and the argument you put forward. But you have the right under the law, as an asylum seeker, who has waited for 12 months plus to apply for permission to work in the UK.
Well, then with that, let me quickly look at my question. I would want you to consider and answer for me. Now, it says that on April 20, 2023, Kofi Asare arrived in the UK with a visitor's visa. He arrived at Heathrow Airport, and when the immigration officer searched his luggage, they found another birth certificate with a different person's name for his father. Therefore, they detained him since they became suspicious that he did not have a relation with father. Asare then made an asylum claim, and after a year, the decision was still pending. Mr. Asare then made an asylum claim, and a year after, the decision was still pending. Can Mr. Asare obtain a working permit as an asylum seeker? One, yes, if he is dependent on his father and over 18 years old. Two, no, because he is an asylum seeker and was detained. Three, because he put in his asylum claim at least 12 months ago. Or, well, it's none of the above. Yeah, think of that. We will be coming back to that in a moment or two and see what answers you have. Remember, the lines are still active: 0208-493-7345, or you can text 0739920848. Send a WhatsApp to the same number, 0739920848. Is it 1, 2, 3, or 4? Okay, let's get back to our discussion, and let me pose this question. Last month, with 39E, for instance, if I have been asked to make up the time when I applied under the 39E shield is what I am depending on. And within that period, there are exceptional circumstances that may warrant me getting a quick indefinite leave to remain. For instance, domestic abuse. Can I then rely on that and not make up the time and apply earlier?
So, under human rights concessions, there should always be a second party.
Okay.
Domestic violence, yes, there should be a second party.
Okay.
So the question is, the application being made, is it based on a second party, or based on the person themselves, or based on their child? So if yours is based on your spouse, that's the second party, then it should work. Because if that second party is now making life unbearable for you, and there is element of domestic violence, then you can make an application that maybe by the time you are ready to proceed, they are not even willing to support your indefinite. And they are threatening you that, this is punishment even from God. No wonder you didn't get it. It's because of your behavior. Now I will see when your time is up, indefinite. I'll show you where.
I like the way you put it. It's typically what people would say, isn't it?
Emotional blackmail, isn't it?
Yeah.
So the person says all this. So the person is going to go through trauma. Because that is part of abuse, emotional abuse. So the person, the spouse, be it man or woman, would then have to consider applying under domestic violence provisions or concessions, because they fall under that, because they are sponsored by their spouse, and the spouse, for whatever reason, is become abusive, and it's likely that they will not be willing to sponsor even their indefinite leave to remain. So they have to now resort to the support from the state to survive. So if you are going to resort to support from the state eventually, why don't you do it now? So to answer your question, if it is a spousal application and you are waiting to serve your time, quote unquote, and there is evidence of domestic violence, you can switch to make your application under domestic violence. For that one, there's no element of section 39E, paragraph 39E.
Okay. Kevin Asamoah comes up with a question. Kevin, let's pick up yours. Yes. How long does TB result take to be ready in Ghana? That'll be a difficult one to answer.
I mean, we can answer.
Oh, okay. How long does it take?
Some people get it the same day, some get it in a week. So if you want it early, go for it early.
Oh, okay. The earlier, the better. And I think it goes with the advice we have been giving about 39E, 39E and 3C, that paragraph 39E and section 3C. If you want to be protected by 3C, section 3C, and you can use that as a sword, then apply in time. But if for any reason you are not able to apply in time and you fall under 39, paragraph 39E, then it means that when you get to your indefinite leave to remain, you would be referred to make up the time. And that is what we are advising against. Well, let me tell you, Lawyer Charles Asma is ready to support you. BWF Solicitors is ready to support you. If you want to speak to Lawyer Charles Asma, you can call him on 07947 63 60 37. 07947 63 60 37. Okay, so it's time for us to come back to our quiz. But before then, Lawyer, is there anything we could add about that?
So we'll crave your indulgence. Want to show viewers some of the evidence they can add to challenge this predicament.
Fantastic.
So, producer, kindly assist us. So, this one piece of evidence. Do the main application by paying the main fee. This is the main fee, which comes after the IHS. So this one piece of evidence I submitted 13th of June, and we can work out whether it was within or outside. So that's one piece of evidence. The other piece of evidence, please. So again, this is somebody who was issued the fee waiver, a successful fee waiver, 10th of June. And application must go within 10 working days. If you go further, which is not available, they will tell, Home Office would have said that if you make your application within 10 working days, the starting point of your application will be the date of your fee waiver application. And therefore, you have your fee waiver application, you have the fee waiver decision, and you have the application submission date. Confirming that you submitted within 10 working days. So, what is the Secretary of State saying? That it was within the 39, paragraph 39E. Right. So, these are a couple of evidence that somebody challenging such decision can rely on. What does it tell us? It means any piece of immigration application, we have to make sure that we have a copy of it, or the necessary screenshot that our lawyers share with us, we have to keep them. Somebody will wait, and once they hit, they go back to the lawyer to say, lawyer, do you have them there? What if the lawyer, if for whatever reason they are not able to get that piece of evidence? So let's keep them. Let's keep them. Let's keep them. But you never know what can
happen. All right. So then it's about time we went for our quiz. The question again is this. On 20th April 2023, Kofi Asare arrived in the UK with a visitor's visa. He arrived at Heathrow Airport, and when immigration officers searched his luggage, they found another birth certificate with a different parent name for his father. Therefore, they detained him since they became suspicious that he did not have relation with the father. Mr. Asare then made his asylum claim, and after a year, the decision was still pending. Can he, that is Mr. Asare, obtain a working permit as an asylum seeker? The answers are One, yes. If he's a dependent on his father and over 18 years old, he can obtain a working permit as an asylum seeker. Number two says no, because he is an asylum seeker and was detained, so he can't. Number three says yes, because he put in his asylum claim at least 12 months ago, so yes, he can. And number four, we like those who would want to stay on the fence. None of the above. Get your answers ready. I'll pick them up right after this break.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we're back, and let's see what answers we have. I just want to reiterate that this question was put on social media earlier in the week, and a few of you may have tried your hands on them, and we will be picking your answers as well. Charles Emery says number 3, yes, because he put in his asylum claim at least 12 months ago. Samuel Odruansa says number 3, yes, because he put in the asylum claim at least 12 months ago. 2 of the number 3s have come through. Robert Jemfi, no, because he is an asylum seeker and was detained, so he cannot obtain a working permit as an asylum seeker. What next? We have Angela Kusi. Asari can obtain a working permit as an asylum seeker because if he is a dependent on his father and is over 18 years, so he can do that. Well, let's see what Emilia says. Emilia says number 1 as well. Yes, if he is a dependent on his father and over 18 years, he can obtain a working permit as an asylum seeker. Kevin Asamoah says yes, it's number 1. If he is a dependent on his father and over 18 years old, he can obtain a working permit as an asylum seeker. That was Kevin's bid. Thank you very much. Marking Team says number 2. No, he cannot obtain a working permit as an asylum seeker because he's an asylum seeker and was detained at the airport. Tilly Duma says number 1. If he is a dependent on his father and over 18 years, he can obtain a working permit as an asylum seeker. Who else has an answer for us? Let's see. Susanna Adams, number 3. Mr. Sari can obtain a working permit as an asylum seeker because he put in his asylum claim at least 12 months ago. Well, that was Susanna's. Thank you very much. Let's see. Okay, Tilly is number one. So let me go to Lawyer Asma whilst we have some time for him to take us through what the scenarios are and what the possible correct answer would be. Lawyer Asma.
Thank you very much. So we go back to have a quick refresher on the nugget. You don't have to put a nugget on the board, though. So it says that Home Office must consider an application by an asylum seeker for permission to work while they are waiting for the decision. However, that person seeking asylum might have waited for at least 12 months. The guidance of 28th of October 2022. We look at Asari. So we have to go through the checklist. 1, is this person an asylum seeker? Yes. Forget about anything else that happened. He put in an asylum application. So he's an asylum seeker. Number 2, has he waited for 12 months? Has he waited for 12 months?
Mr. Asari then made his asylum claim after a year. The decision
is pending after. So he's been waiting for 12 months. The word is can, not must. Can he be given permission to work? If he made an application, that must be considered. He can be given permission to work because he meets the criteria. He's an asylum seeker and the application has been pending for at least 12 months. And so it's 3.
So it's 3 years because he put in his asylum claim at least 12 months ago. Listen, you just don't look at that and say it is that. Look at the scenarios, look at the steps, look at the keywords and key situations. The answer is 3. Mr. Asari's asylum claim has been pending for over 12 months. So those who put in 1 and 2, and I didn't get anybody saying none of the above because at least some apply. And yes, and with that, we will be asking you to look out on our social media platforms, BWF Solicitors. During the week, we'll bring you the next scenario and then you can go through it. Then we will bring it up on the program and look at what the possible answers will be. And with that, let me go over to Lawyer Charles Asma again. I would want to reiterate on the screen, we have Lawyer Asma's number there, 07947 636037. If you want to talk to him, you can contact him directly on that. Lawyer Asma, what have we talked about today?
Viewers and listeners, once again, thank you. So the deferred greeting is now offered. A very wonderful afternoon, evening to everyone, wherever you are. And we bring you same from the corridors of BWF Solicitors. So to recap, we said that it is possible that the Home Office will be confused as to whether your application still falls under paragraph 39E of the Immigration Rules or Section 3C of the Immigration Act of 1971. When it gets to the point where they get it mixed up and your application is indefinite, they are likely to say that you only have a shield and not a sword, and therefore you don't qualify for indefinite. Once it happens like that, you have the right to challenge them if you have all your evidence intact. What evidence do you have to prove? Evidence that you made your application before the visa expired. So a copy of the application front page showing the date of application and the time of the application. If you applied for a fee waiver and therefore by the time the fee waiver decision came, the visa had already expired, then you need the fee waiver application showing the date of fee waiver application and the time of fee waiver application. You also need the fee waiver decision showing the decision either to grant or to reject or refuse, so to speak. If you were granted fee waiver, whether you applied within 10 working days and so you still operated under 3C. So you need evidence that you made your application. What do you need? Front page of your main application showing time and date. You may also offer as evidence or provide as evidence the payment confirmation which shows that you pay the IHS and you pay the main application of 1,048 as well on a date. If that is the case, you are covered and you can use them to challenge. Even if your fee waiver was refused, you have the decision to say that now apply in 10 days and pay. If you applied in 10 days and paid, 10 working days and paid, then you have to provide evidence of the refusal decision of the fee waiver, the date, the original fee waiver application, and the final application you submitted with the payment you made. These are pieces of evidence that you need to support the challenge that the Secretary of State has made, or the caseworker has made a mistake to not to grant you your indefinite leave request because they thought that you are still in arrears of date because you applied your application, you made your first application after the visa had expired. This is what we have covered. We believe that it will help anybody that will have to challenge the Secretary of State for such situations. And once you are challenging them, you can also ask for compensation for the loss of earning if employment has been affected, and also legal fees if you needed a lawyer to put in that challenge for you. You will succeed with the evidence you are going to provide. And again, compensation, you have to provide the evidence of the cost. And if they don't, you can go to court for judicial review, which certainly the court will agree and offer you the remedy you seek. Thank you for making time.
And I want to say thank you for also sticking around and making sure that we had a very successful program. Thank you to my guest and resource person, lawyer Charles Asma from BWF Solicitors. You realize that if we have people coming and spending their Saturday afternoon with us, we would have to be very much appreciative of that. So, Lawyer Asma, thank you so very much. And in the global and general sense, I want to say thank you to BWF Solicitors, our trusted partners when it comes to the law, for supporting our program and also giving us the opportunity to come your way every Saturday afternoon on the program, The Community and the Law. To the family of BWF Solicitors here in the UK and back home in Accra, Ghana, we want to say to every one of you, your contribution is massively appreciated, and we would want you to continue with that. And to you viewers and listeners out there, thank you so very much. Remember, we're live on BWTV, and we do that on the platforms BWF Solicitors on Facebook, BWF Solicitors on YouTube, as well as BWTV, both on Facebook and YouTube as well. So click on the notification button, click on that, and just stay back because we will be putting content on the platforms every now and then so that you'll be notified of that. And then like the page and share with your friends and other people who may not have heard about what we do here on BWTV. And to my studio producer and director, Professor Ade, to Padma Dodu and Sheila Ankara for your contribution now. Mayete and Pamela, to you, thank you so very much for your support. And to you out there, thank you for staying with me. But I want to invite you to come join me again, same time next week. My name is Owusu Frimpong. Good evening.